Hello, I'm Daniel Benjamin. I am the president of the American Academy in Berlin, and I'm delighted to welcome you to this Lloyd Cutler lecture entitled 51 Imperfect Solutions, States in the Making of American Constitutional Law. Our speaker today, I'm delighted to say, is Judge Jeffrey S. Sutton of the U.S. Court of Appeals for the Sixth Circuit since 2003. So I particularly want to welcome our viewers. This is a truly global virtual event. Judge Sutton is speaking to us from Columbus, Ohio. I am speaking to you from Norwich, Vermont, and I know we have viewers, many in Germany and many in other countries. It is a real pleasure to be presiding over a Lloyd Cutler lecture. Lloyd Cutler was, of course, one of the great figures in Washington and in the law for many, many years. I had the fortune of working in the White House when he was White House counsel for a brief period. And I am really pleased that so many people from his former firm, Wilmer Hale, where he was a named partner, are joining us today. I'll just say one of my favorite anecdotes about Lloyd Cutler was that during the 5.5 years I spent on the National Security Council staff in the 1990s, I had a colleague who was himself a distinguished academic lawyer, and whenever we faced really large problems, he had the habit of saying, what we really need to do is to create a blue ribbon commission and make Lloyd Cutler the head of it to deal with this question. And it was always a great solution, but one that we could only resort to every once in a while. Anyway, our speaker today, Judge Sutton, as I said, has been on the Sixth Circuit since 2003. He had been a state solicitor for the state of Iowa. Oh, excuse me, the state of Ohio, pardon me. He clerked for Judge Antonin Scalia, who was likewise a Lloyd Cutler Distinguished Visitor at the American Academy in 2009. Supreme Court Justice Lewis Powell as well, and Judge Thomas Meskill, who had a fascinating career and was governor of my home state in Connecticut before he became a judge on the appeals court. I'm delighted to also say that Judge Sutton has agreed to talk to us a bit after he discusses the issue of state and federal constitutional law, to talk a bit about the Supreme Court confirmation process currently going on and some of his experiences on the court as well. He is the author of the eponymous 51 Imperfect Solutions, which I might add was mentioned just yesterday in her hearing by Judge Amy Coney Barrett, excuse me, I seem to be misspeaking today, Amy Coney Barrett. And he is co-editor of a volume entitled The Essential Scalia on the Constitution, the Courts, and the Rule of Law. So let me just say before we start that Judge Sutton will speak for a bit on his book and on the issue of constitutional law. I will speak to him a bit and pepper him with some questions, and then we will open it up to the audience. Please feel free, as soon as you like, to send in a question. Please send it in through the Q&A function on the Zoom screen. The raise your hand function will not be activated, so don't go there. And I will do my best to get in as many of those questions as I can. And with that, I want to thank you again, Judge Sutton, for joining us today. Say how sorry I am we're not doing this together in Berlin. We still very much look forward to welcoming you to the American Academy when the pandemic recedes and conditions permit. So with that, let me turn it over to you.
All right, thank you, Dan. It's a real honor to be here. Really a double honor for my family. I learned the other night that my aunt, Linda Henderson, was a Academy Fellow in the spring of 2014. So I feel particularly honored to be able to give the Cutler lecture today. I am in Columbus, Ohio. Behind me, you've got my courtroom, which is in Cincinnati, and over one shoulder is William Howard Taft, who was a judge in our court for about 8 years early in his career. So we're Berlin, Cincinnati, Columbus, Vermont, all over the place. It's quite humbling to write a book about state constitutions, and I can illustrate that point in 2 ways. Soon after the book came out, I was coming out of church, and a retired doctor friend of mine, Dick Briggs, stopped me and said, "Jeff, I'm so excited to hear you've written a book. That's really, really fun. Is it a mystery? I love mysteries." And I had to tell Dick that no, it's not a mystery. And he said, "Well, is it an autobiography? That might be interesting." And I said, "No, Dick, it's not an autobiography." And then a little frustrated, he said, "Well, what's it about?" And with far too much enthusiasm, I said, "State constitutions." Well, poor Dick Briggs is a very polite guy. He had no idea how to respond to that. Long, awkward silence. And finally he said, "You sure it's not a mystery?" And fair point. It gets worse and closer to home. Happily married to a 7th grade English teacher. When it was time to send this book off to Oxford, I asked Peg if she would take a look at it. I'm sure I had some dangling participles here, subject verb disagreement problems there. I gave her the book on a Friday, and by Sunday, she was only a chapter and a half into it. And the first chapter is only 6 pages, so I didn't consider that a compliment. I said, "Peg, you know, what gives? I thought this was a little more of a page turner." And she said with far too much seriousness in her eyes, "I don't love you that much." Now I will say, in her defense, she did eventually finish the book, and I'd like to think it is a little more of a page turner, but let's go back to my friend and think of this as a mystery, and what I would call several mysteries about state constitutional law. And let me start with perhaps the most conspicuous. Why would a federal judge care? I've been a federal judge for 18 years. I've not had one significant state constitutional law issue. We don't get that question very often in our federal system. The state courts handle most of the state constitutional issues. The federal courts and the state courts handle federal constitutional issues. So in some ways, it parallels the German system with its federalism. The thing that got me interested in state constitutional law actually was being a federal judge and perhaps going through the confirmation process. My first year of law school was 1987. And since 1987, I would say the trajectory when it comes to federal constitutional law is that the federal courts, generally speaking, are exercising and have exercised more and more power over time. Now, in one sense, that makes it look like my ship has come in. If one has a job in government, one would rather have a portfolio with more power rather than less power. If you manage money, you'd rather manage more rather than less. So in many ways, this trajectory has been very good for someone who landed in the federal courts, as I did 18 years ago. There's one small problem, however, and that's that the American people, fools though they may be in the short term, are not fools in the long term. The American people have come to appreciate the power the federal courts are exercising, whether it's the US Supreme Court or the lower federal courts. And so that is exactly why we have a situation where, you know, one year you have red rights, next year blue rights, red, blue, escalating colonization of new areas for the federal courts to control. In fact, we've reached a point where it's fair to say the American courts embrace judicial review, constitutional review, more than any country in the history of time. Our system very much embraces the role of courts in protecting liberty, property, other freedom type rights. But it has created a problem, and that problem is the risk of politicizing the courts. Because if the courts continue to exercise more and more power, the American people are going to want to have a say in who those judges or justices are. And that, of course, explains the current confirmation process. Justice Scalia, back in the mid-1980s, was confirmed 98-0. To see it on the court, Justice Ginsburg, his friend, was confirmed roughly 96-3 in about 1993. Of course, that wouldn't happen today. In fact, my confirmation was 52-41, and I'm just an intermediate junior varsity judge. So this trend of the federal courts exercising more power has been consistent with the American people taking a greater interest in who these judges are. And 4 years ago, we really illustrated the problem when a presidential election turned by too many counts to deny on a sufficient number of people picking a president of the United States as a proxy to fill one seat on a 9-member court. That's really not what the framers had in mind, whether it's 1776 or 1787 when they met in Philadelphia. So how do we get off of this escalating rights problem? I have a glib answer and I have a more serious answer. The glib answer is for all 320 million Americans to read my book. The more serious answer is to get a detente where perhaps the federal courts are not exercising quite as much power in American government, where there is a little more balance of power between state and federal government and among the branches of the federal government. And you have to ask yourself, how do you get a detente? Detentes are notoriously difficult to arrange because both sides always feel like they are losing more than they are gaining. And I really do think quite seriously that state courts and state constitutions are an answer to that problem. As I pointed out earlier, no country in world history has embraced judicially enforceable rights more than we Americans. Germans certainly don't embrace them the way we do. And it seems to me very difficult to swim against that historical stream. Far wiser to accept that, but just prefer, or perhaps hope, or perhaps design a system in which more of these judicially enforceable rights and these disputes are first take place at the state courts under the state constitutions. So that's mystery number one as to why the federal judge would care. It might help us save the federal court system. Mystery number two, how is it that we forgot about state constitutions? That's also puzzling. Every federal constitutional guarantee that we Americans prize, whether it's free speech, equal protection, due process, search and seizure, the criminal procedure guarantees, every one of them originated in a state constitution. Indeed, as Gordon Wood acknowledged, the greatest era of constitution writing in this country, indeed in world history, was between 1776 and before the fabled summer of 1787 in Philadelphia. Most of what happened in Philadelphia in 1787 in adopting the federal constitution was borrowing from the state models already in existence. When it came time for the Bill of Rights in 1791, that again was really a cut and paste job, using various rights identified in the state constitutions. So it's very strange that these rights we embrace so much originated in a different set of constitutions, and yet we've forgotten that history. I suspect one explanation might be the Warren Court, when, partly in response to Jim Crow, perhaps in response to other things going on in American history, the federal court very much became a leader in rights innovation. And well, it's very easy to accept all of those decisions. It did have one slightly negative consequence, which it created what I would call the danger or peril of a single story. The single story being that there is just one set of rights that matter in this country, federal constitutional rights, and one court, the US Supreme Court, that can be counted on to protect them. And that seems to me quite dangerous and ultimately leads to myths. And the myth being the US Supreme Court and federal courts always get it right when it comes to rights protection, and the state courts always get it wrong or can't be trusted when it comes to rights protection. So I guess that answers the second mystery, how it was that we forgot about these state constitutional rights. Third mystery, how is it that a state court could protect rights when the US Supreme Court does not? So if you think of the the US Supreme Court's gerrymandering decision a year or so ago, about 18 months ago, where the US Supreme Court in a close 5-4 decision decided not to exercise judicial review over gerrymandering, extreme partisan gerrymandering decisions of various state legislatures. Well, state constitutions impose a separate, distinct, freestanding limitation on all exercises of state and local power. That means state courts are free to use their state constitutions to regulate, oversee, and if need be, invalidate extreme partisan gerrymandering. And indeed, 2 state courts have done just that. One, Pennsylvania Supreme Court decision before Rucho, and a North Carolina Court of Appeals decision after Rucho. In both cases, they, of course, couldn't rely on the federal Constitution because the federal Constitution was found by the US Supreme Court not to apply to extreme partisan gerrymandering. But that didn't prohibit the second shot being taken by claimants who wanted to focus on a gerrymandering problem in their state and who argued successfully that their state constitution protected it. So there really is an American government, 2 safeguards of liberty or property rights, the federal Constitution on the one hand and the state constitution on the other. Now, why is it I guess I'm at mystery number 4. Mystery number 4, how would a state court do that? Why would a state court choose to disagree with the US Supreme Court in construing a due process, equal protection, free speech guarantee? Well, the best explanation, as it turns out, is that most state constitutions are written quite differently from the federal Constitution. If you're having trouble sleeping tonight, and you happen to be American, pick out your state constitution and just read Article 1. That'll be the Bill of Rights or Declaration of Rights. And you'll see, quite surprisingly, how many more guarantees there are there than in the US Constitution. And you'll see that they're written often with much more detail, but above all, different language. Different words can lead to different meanings. So there's nothing that prohibits a state court from protecting its citizens from an overreaching prosecution, overreaching law based on that state constitution. Think of it this way. Think of something like the free exercise of religion. Imagine a state court based in Utah or Rhode Island or Pennsylvania or Maryland. All 4 states were founded by religious dissenters. It makes considerable sense that given the history of those 4 states, they might take the free exercise of religion a little more seriously than other states or perhaps the US Supreme Court. And this gets to a really big advantage of state constitutional law. The US Supreme Court is not allowed to customize its interpretations of the federal Constitution to account for unique cultures or histories or anything else that's unusual about a given state or a region of the country. They, of course, are supposed to be interpreting the Constitution for all 320 or 330 million Americans, all 51 jurisdictions and thousands of towns and cities. A state court, by contrast, can customize its interpretation of its state constitution to account for the people of that state, their history, their traditions, whatever they might be. A second ground that is quite important is that there's nothing that prohibits a state court simply with disagreeing with the US Supreme Court. When the US Supreme Court interprets a phrase like due process or equal protection, unreasonable search and seizure, those are phrases that demand disagreement. You can't say the word unreasonable has one meaning in all settings when it comes to a search and seizure. That's a really hard argument to make. So the general terms that are often being fought most aggressively about at the US Supreme Court are often the same types of general phrases at issue in state court cases, and state court judges can and indeed often should take those general phrases and customize their meaning to account for the preferences of the people in that particular state, maybe even that in particular reason. And then, of course, sometimes, I hate to acknowledge it as a federal judge, we're not perfect. We make mistakes, and sometimes we just get it wrong. There's no doubt that's going to happen. Some of the chapters in the book, one of which I'll return to in a bit, is an example where the US Supreme Court, Buck versus Bell, just got it wrong. We wouldn't want a system in which state courts are slavishly following federal court interpretations, even when they're quite mistaken, even misbegotten. Last mystery. How might this be useful, and how might it actually be helpful for federal constitutional law? Well, in American law, one of the great justices is Justice Louis Brandeis, and he had a view of American federalism that most Americans, in fact, it's very hard to find something in which all Americans agree these days, but I'm pretty confident this would be one of them. That when you have a new policy problem, data privacy, opioids, or perhaps the pandemic, when it's not clear exactly what the policy answer to the problem is, Justice Brandeis made the point that a brave state could try out an experiment, a bold experiment, and if it worked, other states could follow it. If it didn't work, other states could learn from those problems and adopt variations on those solutions. Over time, we might develop a right answer, in which case we could nationalize it, or we might find out there really is no right answer, and it's best to have 2 or 3 schools of thought for dealing with this problem. And when Justice Brandeis referred to our states as laboratories of democracy, he was referring to state legislatures, the key policy-making arms of American government, and the Congress. Everything I'm saying in the book is simply taking that wonderful metaphor and saying we ought to develop federal constitutional law in exactly the same way. We ought to have 50 laboratories of state court experimentation with the meaning of unreasonable search and seizure, due process, cruel and unusual punishment, equal protection. When winners emerge, winning insights emerge, we nationalize. But the key idea is have the states be at the vanguard of rights innovation, rights experimentation, and get out of the business of racing to Washington for the winner-take-all victory, which is, of course, very tempting if you win, but incredibly depressing if you lose, and often leads to resentment when you lose, and may explain some of our polarization. So the Brandeis insight, it seems to me, carries over quite well to state constitutions. Another advantage for federal law is state constitutions, federalism in general, happens to have a quality that's sorely missing in American law these days, and that's that it's utterly neutral. It doesn't inherently favor liberals or conservatives, Democrats, Republican, red state, blue state. I can prove the point that by pointing out that Justice Brennan, very prominent US Supreme Court progressive justice, wrote a landmark article in 1977, very much embracing the idea that we ought to use state courts and state constitutions as laboratories of experimentation, just as I'm saying. On the other side of the aisle, Justice Scalia, in his last majority opinion for the US Supreme Court, a case called Kansas versus Carr, made these exact points. Now, when Justice Brennan and Justice Scalia agree on something, you're getting very close to a biblical truth. The two of them did not agree on a lot, and when they did agree, the odds are very high. They had an insight worth embracing. And let me illustrate the last way in which this could be useful for federal con law, and really the last point I'll make before Dan and I begin our conversation. And it goes to a chapter in the book about a very unhappy chapter in American history, the eugenics movement, which started in the early 1900s. It was a time in history where the scientists perhaps were getting ahead of themselves, and politicians most definitely getting ahead of themselves. It was a movement that really started with the elite. It was a response to industrialization, the growth of large populations in cities, increase in crime, and an increase with individuals with disabilities of one sort or another. And the basic idea behind the eugenics movement is that some people had defective genes, and the idea would be to eliminate them by not allowing them to breed and allowing those who did not have defective genes to breed. And so this led many states to pass involuntary sterilization laws for people with all kinds of so-called mental disabilities, so-called feeble-minded. The part of the story that most people don't know is that the heroes of the story were actually the state courts. It's really a story that shows that federalism is liberty protecting and state constitutions can be liberty protecting. Several state courts considered challenges to involuntary sterilization laws, and every one of them but one ruled for the claimant. In other words, ruled against the state, ruled against eugenics. And so it's a story that you don't often hear in American constitutional law, where the states are the heroes. And the villain of the story is very much the US Supreme Court, which issued an 8-1 decision in Buck versus Bell in 1927, written by arguably the greatest justice in American Supreme Court history, Oliver Wendell Holmes. It proves ultimately we are all imperfect in one way or another. And Holmes, in a very short opinion, said the US Constitution, whether it's the Due Process Clause of the 14th Amendment, the Equal Protection Clause of the 14th Amendment, had nothing to say about whether a state could enact eugenics legislation. And indeed, at one point, the eugenics movement almost passed a federal law. In 1924, there was a bill proposed in Congress that would have allowed eugenics across the board in every state, whether they'd enacted the law or not. Happily, that law was not enacted. I would assume it's because they may have realized Congress would not have been regulating commerce if it had enacted that law. But the eugenics story shows shows a couple things. States can sometimes be better protectors of liberty than the federal courts. State constitution's better than the federal constitution, so be careful about generalizing in that area. And it shows very much that federalism itself can be liberty protecting because it gives you a second opportunity to put the brakes on a social experiment that may not be a very good idea. You can compare this with Germany's experience with eugenics. Quite sadly, Germany looked to Americans for the idea behind eugenics, and Hitler embraced it in a big way, but you can compare the two experiences in this way. The eugenics movement in the United States lasted about 75 years and led to 60,000 involuntary sterilizations. Pretty grim numbers, but compare that to Germany's experience, where in 13 years, there were 400,000 involuntary sterilizations. How, you might ask, given that Germany today has federalism itself? Well, it's my understanding that was one of Hitler's first moves in taking power, was eliminating the authority of the states and centralizing power in the national government. And that, of course, is what allowed so many more involuntary sterilizations to happen in a much smaller country over a much shorter span of time. You might be interested to know that those sterilizations actually came up. They must have been one of the charges in the Nuremberg trial. And quite fairly, the defense of several Nazis was to say, this was not our idea, Justice Jackson, the lead prosecutor at Nuremberg. This was something you Americans innovated, and indeed in your Buck versus Bell decision you allowed. So I don't know that too many of those counts actually went through. So it's an unhappy story on both sides of the Atlantic, but it does show to me that as bad as it was, it could have been a lot worse in this country, but for the reality we had state courts and state constitutions putting additional brakes on what turned out to be a very bad idea and a bad experiment. So Dan, I'm looking forward to hearing your questions and beginning a conversation. I can't hear you.
Yep. Okay. So thank you so much for a terrific talk and a really stimulating presentation. Let me ask you first a few questions on the subject itself, and then maybe we can roam a little more widely. How do you explain the decline in activity at the state court level on constitutionally protected freedoms? It seems like it would be obvious that those, in many cases, might be more congenial places to begin or to bring suit. Why the rush to the Supreme Court?
Yeah, it's a really great point. I mean, all you have to know is understand American basketball or math. I mean, what person ever got a two-shot free throw and took one shot, missed the first shot, and didn't take the second shot? That's the very thing we're talking about. American lawyers are known for liking to win. American clients are known for preferring victories. I really think it goes back to two things. One is the danger of the single story. I think from 7th grade civics on in American education, when it gets to explaining American government, I'm a former 7th grade teacher, I understand their plight. You're trying to simplify things. And one way to simplify them is when you get to the judicial branch, just talk about one branch, the US Supreme Court, the federal courts, and one constitution, the Bill of Rights. And of course, there's so many American stories that are so much a part of our ethic. I mean, think of Brown versus Board of Education. So who wouldn't want to tell that story? The downside of a single story, though, is you forget this possibility. So I think one problem is purely educational. The law schools for far too long have not taught state constitutional law, so there's a little bit of that going on. But I'm optimistic that things are going to change. So that point number one. Point number two is an interest group problem. If you're an interest group and you care deeply about a given right, so just pick your right, and if you're going to do that, try to think of ones with opposite political valence. It's deeply rational to do one-stop shopping in Washington. You know, why wouldn't you do that? Because there is no better political victory in American government than a federal constitutional ruling at the US Supreme Court that constitutionalized your preferred interest. One, you've got a national victory. That's terrific. You don't have to fight it out in 50 states. But best of all, because it's a constitutional victory, you've sidelined your political opponent. They're not even allowed to vote on the issue. So the incentives are incredibly powerful for interest groups to use federal court litigation with respect to federal constitutional law. You know, why wouldn't you do that? So even though I don't think it's the best way to develop federal constitutional law, I think you're way better off using the laboratories of experimentation approach that Brandeis advocated. I'm fearful that the interest groups have deep incentives to continue the path we're on, to stay in the groove we're in. And that's partly why I've written the book. I mean, I think people have to educate folks about the consequences. And I mean, another way to think about it is, where do you as a citizen want to be in 15 years? Do you want to be saying half the time, I'm really thrilled with this US Supreme Court decision because it just constitutionalized something I really care about, but you have to know full well you're going to win half and probably lose half. And that means there's going to be another ruling with which you're probably going to be deeply resentful because you don't agree with it, number one, and number two, you're now not even allowed to vote on it. And for me, the choice seems really obvious. Instead of being ecstatic half the time, deeply resentful the other half, why aren't we trying to fix our problems locally, have the courage of our convictions that they're good ideas, and if they are good ideas, a state court ruling in Ohio, nothing prohibits them from being exported to other states and developing a grassroots from momentum that this is how you think about this idea. I mean, a controversial issue in America, but one that illustrates my point, is the marriage story, which I think everyone understands, but they may not understand all of it. 1972, the US Supreme Court issued a decision in Baker, and they put up a stop sign. 9-0 decision. They said the federal constitution does not speak to marriage equality. That's just not something it covers. So 1972, pretty liberal court, not a single justice was for it. At that point, if you thought marriage equality was a good idea, you had two options: stay unhappy or go to the state courts and state legislatures. Well, that's what happened. They went to Hawaii in the early 90s, had a victory, a little bit of a retreat, Vermont Supreme Court victory, very important decision, the Massachusetts High Court in 2003 in a case called Goodrich, some coming back and forth, finally gets up to the US Supreme Court in 2013. They have a chance to nationalize it. They don't at that point. And then in 2015, in the Obergefell decision, they finally nationalize marriage equality. So that's a story from 1972 to 2015. And, you know, I'm a federal judge. I can't predict where things are going to go in the future, but it's hard to ignore the reality that the groundwork was laid for that decision. And it's probably a decision that it may have been controversial at the time, but has gotten less controversial over time, in part because so many state courts and state legislatures had already dealt with the issue, which means you lower the stakes.
Well, let me ask a follow-up question on that. It would seem to me, admittedly a non-lawyer, that the value of going through state courts first would be pretty obvious, because if you get a negative judgment at the Supreme Court, it's going to have a profound chilling effect on whatever you might want to do at the state level. You just gave an example where that was not true, talking about marriage equality. But is it not the case that, you know, more often, that frequently losing at the Supreme Court would set your causeway back?
Yeah, no, it's a nice point. If I'm going to say we live in a world where there's the peril of a single story, and we live in a world where most people think of the definition of our rights coming from the US Supreme Court, I agree with you that there is some danger of starting out at the US Supreme Court. And I suspect the answer is there's a lot of litigation, there's a lot of state laws, and it's not exactly easy to control Americans. I mean, all it takes is one American to file the lawsuit under federal law. You know, we judges don't control who sues when. We take the cases as they come. So in that sense, it's not really a coordinated effort. And so I don't know exactly what happened with the Baker case in 1972. But I suspect interest groups think about that. So I'm quite confident the interest groups would ask themselves, what are the odds that the US Supreme Court would take this particular claim seriously? And they might be strategic in the way you're talking. But, you know, if you think of a criminal procedure right, if you're the one who just got convicted, I don't think you much care about Jeff Sutton's idea that you should wait 15 years for the US Supreme Court to address the issue. You're going to be inclined. Now, they should like both shots, though. They should want both shots at that point, because if they don't like prison, I would think they would prefer two chances to get out over one.
So our viewers may have more questions on the issue of state constitutions and the Supreme Court. I'd like to just put a few quick questions to you about the ongoing proceedings. I know you're not going to comment on matters of law, I think, that are before Judge Barrett and are being discussed in the Senate. Our procedures have become incredibly freighted when it comes to Supreme Court nominations. As you mentioned in referring to Justice Scalia, it wasn't very long ago that we saw overwhelming majorities supporting most people who were elevated to the court. And I am curious if how you view the development where we now have very narrow, very, very narrow votes, and in particular, whether that issue isn't in some way exacerbated by the approach of most nominees now, which is to pretty much dodge all the big questions and say, well, I can't really talk about a hypothetical that might come before the court or something like that. And that while we get some descriptions of judicial philosophy, we're really not getting a lot in terms of anything that would allow us to predict how a judge might rule on particular issues. Anyway, why has this become so sharply contested a process, and are we being served by the current approach towards nominations?
Well, federal judges and federal Supreme Court justices can disagree intensely about a lot of things, but this would not be one of them. We're all very nervous, frustrated, disappointed about what has happened. Justice Ginsburg shared that view. Justice Scalia shared that view. I think Justice Ginsburg made the point, I wish we could go back to the days when Nino and I were confirmed. And, you know, both of them would have had a very hard time getting confirmed today. And the thing that I think is so troublesome to the judge, almost existential, is the idea of judging is to be neutral, to not be thought of as wearing a red robe or a blue robe, as a Republican nominee or a Democratic nominee. That really defeats the idea of having an independent court system, having the courts as a neutral, independent check. And what's getting difficult is to continue to carry that argument when, as you point out, confirmation votes have become almost 100% partisan. So the last Supreme Court justice, I think only 2 people crossed the aisle. I think 1 Democrat supported the nomination and 1 Republican voted against it. At the lower courts, which don't matter as much, some of them are 100% partisan votes. So what do you do about this? Now, the thing that is hard about it, and it took me 2 years to get through the process, so I didn't enjoy it myself. But the thing I came to appreciate about it is it's deeply rational for the American people to care so much about this and to be pushing their senators or presidents to take positions that are consistent with their views. I mean, if you think the federal courts are going to exercise power over something you really care about, and that is the center of power, what else are you going to do? It's very strange to say to the American people, calm down. Would you stop agitating about this? Would you stop electing senators and presidents based on your preferences for the court? When they're going to respond, well, the courts are the ones handling the issue I care most about. And what do you do about that? So it's really a tricky problem. And that's why I think the only answer is the courts continue to colonize more areas. And it has the benefit of being neutral in the sense that one day it's beneficial to progressives, the next day it's beneficial to conservatives. But that's a path that ends in tears, in my view, because it's a path that takes this crown jewel of American government and makes it deeply politicized because it looks like a red-blue court. And then what are we going to do when our Brown versus Board of Education moment comes and we need a 9-0 ruling to get the country through a tough episode in history? And is it going to be there? And that's a really troubling point to me. So that's why there has to be some form of détente, but you're not going to get a détente if the average American continues to say what they say today, which is, I love these rights, I hate those. I mean, that's not helping anybody. It's a who decides question. You either have to say the court gets to decide the things you love, in which case the other side gets to do the same thing, or we all go back to the quaint idea that most of this gets resolved through the legislature. And I don't know, to me, that's the conversation that we're going to have over the next couple of years. And it's a really difficult conversation because think about the issue you might care the most about, or the 3 or 4 you and your family care the most about. How can you take that out of your mind if it might mean the court doesn't protect it anymore as a way of depoliticizing the court? You're not going to be happy with that. Most people won't be happy with that.
Of course, the flip side of that is our legislatures are totally paralyzed, certainly at the federal level. So that makes it even more difficult.
Yeah, so it's a fair point that one reason the court has been thrust into so many things is you don't get congressional action sometimes. So I mean, you have I may have my dates wrong, but I think the Clean Air Act comes from 1970 or so. And in 1970, I'm not an expert on this, but I'm pretty confident people didn't know a lot about greenhouse gases. It's pretty strange to have the court trying to figure out how a 1970 law applies to something that's a new phenomenon that science has helped us to understand. So your point's a really good one. If Congress isn't updating laws when they need to, they're going to thrust the court into it. I will say this has a chicken egg problem to it. If you're a member of Congress and you know full well the court may be willing to do your bidding for you, you've just given them an incentive to stay on the sidelines. So it's really tricky.
Right. But let me ask you sort of a more precise question about Supreme Court confirmations and judicial confirmations today. And I know that Judge Barrett is also a former Scalia clerk, and you're all part of a club, as every clerk of a particular justice is, and that you're friends. So I don't mean to point any particular criticism at her, but at this point, are we really served by candidates for courts saying or declining to say, for example, that Brown versus Board of Ed or Griswold, or which Griswold versus Connecticut, I believe it was. Is that correct? Yes. Which made the provision of contraceptives legal on a national basis, or any of these other landmark decisions, not simply saying that they are rightly decided or would, stand up to any court challenge at this point. And in fact, I believe that Judge Barrett said the good news on Brown is that no one's going to challenge it, which is not an entirely encouraging response to my mind. But you tell me, where is the problem here that people up for confirmation would be less than forthright on these issues?
Yeah, so to be clear, I haven't watched the proceedings. I'm too busy, so I don't know exactly what she said. I've read a couple accounts. I think she might have said something slightly differently. I think she might have said Brown counted as the kind of super precedent that you can opine on, but that Griswold didn't, but that Griswold was one not likely to be challenged. I thought that's what I read, but again, I didn't hear it firsthand, so I have no idea. But that's not your real point. Your real point is, why aren't they just getting up there and saying, okay, fine, I'm for guns, I'm for abortion, I'm against campaign finance, and they just give thumbs up, thumbs down. I mean, that's what the American people want to hear. Like that's exactly what you want to hear. And that is what the average American, particularly the non-lawyer American, wants to hear. Are you for me or against me on these 10 issues? And we could change the world and go down that road. No one's done that. Justice Ginsburg didn't do it. Justice Scalia didn't do it. No one's done it. And if we went down that road, that really would confirm that our Supreme Court just is a House of Lords, and it's just the third branch of the legislature, and you just put people on there because of their policy views about guns, abortion, campaign finance, whatever it might be. And I can promise you the judges don't want that. That's not what they see when they look in the mirror in the morning. They do not see a policymaker. They see someone who is supposed to implement someone else's choices, whether it's construing the statute or construing the Constitution that someone else enacted. Justice Scalia famously, you might be amused to know this, if you think it's bad now, in 1986, he would not even admit whether Marbury was good law. So Marbury is like the foundation of all con law. Marbury is the case where Chief Justice Marshall wrote an opinion saying that the federal courts have authority to invalidate acts of the legislature. He wouldn't even answer that one because he knew full well if you answer that, then you go to the next. And he just thought there was a problem with that. So then that gets to the ethics issue. And the ethics issue is quite serious for a sitting judge. So remember that Judge Barrett's a sitting judge. So whether she's confirmed or not, she's got obligations in her current situation. But it looks like I'm trying to defend this, and I guess I am, but you're free to push back on me. The perspective of the judge is, listen, I may have lots of ideas about lots of things in con law, but all of that goes to the sideline when I get a case. And when I'm a judge, or if you're a justice, you're supposed to look at this in a fresh way. And so what I think you're really hearing them say is, as a matter of ethics, I don't think I'm allowed to opine on that, number one, because a variation of that might come before me. But number two, you don't even want me to say that. What you really want me to do is be the kind of person that whatever my current thinking is about this or that issue, when I get that case and those briefs and you, the advocate, is right in front of me, I'm going to be totally open-minded and really try to see both sides of the issue. And, maybe that's to some people fantasy or not likely to the way it's going to work. But I think that's what we're all trying to do. And for what it's worth, on both, Justice Sotomayor and Justice Kagan took the same path. In fact, it was fun. Justice Kagan, when she was a professor, wrote an article that was a little bit like your impression that why aren't they just getting up there and just saying I'm for this and I'm for that? And she realized, wait a second, if I do that, how am I going to be a neutral judge? I'll have to recuse in every case.
Yeah,
Very hard.
That article has resurfaced again, and I've seen it, and I understand that it is that this is a really tough issue. But I guess the I'm for guns, I'm against abortion, I'm for abortion, I'm against guns view, it's not exactly the same as saying Brown versus Board of Ed was a landmark of our jurisprudence. And I have a hard time imagining any case that could push us to overturn it. Is it not?
I thought that's what she said. I could be wrong, but I thought what she was doing was what others have done, that there's some super precedents, I think is the phrase, some super precedents that are beyond reproach, and they're just too much a part of the fabric of American constitutional law. So Marbury versus Madison would fit that. And I again, I didn't watch. I got too much else to do. I don't think they're fun watching those things, but I thought that's what she did say.
We will have to adjourn on that issue and come back and agree or disagree whether that is what she said. So let me ask one more question, which interests me greatly, and I know from some of the questions that have been coming in that it is a matter of interest to our viewers and as well. When you and I spoke earlier, I asked you if you would consider yourself an originalist, which Judge Barrett certainly considers herself, and you said that yes, you did consider yourself an originalist, and because, well, not least because this is I think a fairly foreign concept for attorneys working in Germany. I was wondering if you could give us your robust defense of originalism. And let me just, preface it by saying that for many Americans too, it's hard to wrap our arms around, given that it relies on the judge's assertion that the text was read in a certain way at a certain time, and yet the text from being read in a certain way at a certain time, really doesn't feel like it applies to our lives today. And of course, one of the great examples of that would be something you find in the Constitution, the 3/5 Compromise, which identified African American slaves as three-fifths of human beings. So why shouldn't we just interpret the Constitution in the light of today in the best way that fits the way we live now?
Yeah. So Justice Scalia used to say when he was asked to defend originalism that he sometimes felt the questioner was accusing him of eating children. It's become this a negative connotation to too many people. And let me reframe it a little bit, because I actually think it's really important debate. I think can be misleading the way it's sometimes characterized. And so let me put it this way. I think there's about 114 justices that served on the U.S. Supreme Court. I may have that number wrong, but it's in that department. It's over 100. There's never been a justice on the U.S. Supreme Court that was not an originalist in this sense. No one who served on the court didn't want to know the original meaning of the guarantee, whether it came from 1789 or 1791 or 1868. So when you see a case, a con law case, and they're trying to figure out, say, the meaning of the Second Amendment, everybody agrees if you can come up with a clear originalist answer, that's great. And that's the end of the story. No one's gonna be troubled by that. That's where the debate really comes in, is whether someone stops there. So what characterizes Justice Scalia, and would probably be my approach, is yes, if the answer is clear, what right do we have to do anything other than honor those words? Why else did they put it in writing if they didn't mean it to be fixed in time? I mean, if I bought a house and we had a contract for the house and I was supposed to move in 6 months, and circumstances change between now and 6 months, I wouldn't say the other side gets to rewrite the contract. That's why we put it in writing. And why else did we put the Constitution in writing? They didn't set it to music. They put it in words, and words have a fixed meaning. So what ends up happening is, it's not that the original meaning is something that anyone doesn't want to find out. The problem really comes down to the fact that some clauses, like due process and unreasonable search and seizure, are written, they're just so general, it's sometimes a lot harder to figure out what that original meaning was. And that's where you really start to get the debate. But I think, you made the point that, gee, Jeff, why should I be looking at an 18th century document to deal with a problem in 2020? And the answer is really easy, in my view. It probably means the solution in 2020 has nothing to do with the Constitution. It has very much to do with our legislative bodies. And if we want to amend the Constitution to add that guarantee, we can. State constitutions are a lot easier to amend. That's why there's so many more of those provisions. But I think, so to me, it's just a who decides question. And it really comes back to the confirmation debate we were having. If you decide you'd rather trust your judges to make the decisions about guns, abortion, campaign finance, then you're going to be inclined to say, give them flexible interpretation. If you're less inclined, you're going to say, wait a second, that's for the people to decide through legislation. The last point you made was that it's not as if the original Constitution didn't have some serious defects, indeed outrages. And many people today, whether it's a faith perspective, a gender perspective, a skin color perspective, were not represented very well in Philadelphia in 1787. But the two leading originalists in the country right now do not come from a lineage that was well represented. Justice Thomas, of course, doesn't fit that. And, Justice Scalia, Italian-American Catholic. Go look at the list of people attending Philadelphia. There weren't a lot of Italian-American Catholics at the convention. And his answer to this was, of course they made mistakes in Philadelphia, but they left us free to change. And the way to change was to follow the rules of the Constitution. But anyone worried about fair representation should not want 5 members of the Supreme Court to be in charge of that change, right? Because is the U.S. Supreme Court, or the 9 members of the U.S. Supreme Court, really that representative of the American people? That seems like a heavy lift.
Well, here's a related question from one of our viewers to the issue you were just discussing, and that is, and this has to do with 5 people deciding, and a particular 5 people in this case. If the selection of a judge, or the elevation of a judge to the Supreme Court, depends upon which party has the majority in the Senate, does this jeopardize the separation of powers in the constitutional system?
Well, that's just the system we have. Yeah. I mean, obviously, as we've seen throughout history, it's a different question to have nominees to the federal courts when the president and the Senate are controlled by the same party. We used to have the filibuster in the Senate, which was kind of sand on that slope, right? Sand on that slippery slope, but they got rid of the filibuster for judges and justices. And I'm a judge. I'm not here to complain or not, but that did make it more majoritarian. And if the filibuster, that questioner probably would have preferred the filibuster, because that would have required a more centrist judge. There's just no doubt about it. If you have to get 60 votes rather than 50, that makes a very big difference. I really, I mean, I just don't know how you can have a greater example of the situation than the fact that a presidential election 4 years ago turned on a vacancy at the US Supreme Court. I mean, you can spend the rest of your life reading about 1776 and you're not going to find anybody saying, here, the system we got to design is one in which 5 members of the court are making the key decisions, and they have so much power that we select presidents solely as a proxy to fill those courts. I mean, that's a really, it's an unhappy place to be, is a matter of American history. So I think your questioner is making a balance of power point, and I couldn't agree more.
Yeah.
It's all balance of power. And notice, by the way, this is my predicament in writing about state constitutions. Every time I talk about state constitutions, everyone wants to talk about the federal constitution, which of course is the predicament. And, you know, I think we lower the stakes if we just stop thinking of our system as one where just one court protects our rights, and try to think of it as 51 courts and 51 charters that can protect our rights. That seems to lower the stakes a little bit. And so the winner take all consequences aren't as high octane.
So let me come back to originalism a bit and try to summarize a number of different questions, and also some of the things that have been in the press lately. In particular, I think, you know, the perception now is that originalism frequently winds up being a way in which more conservative judges and justices essentially justify a more conservative outcome. It is seldom the case that we hear more liberal judges making justifying their decisions on the basis of original readings in their view. And I'm wondering how you believe that originalists can combat the argument that this is ultimately a partisan screen for their policy preferences.
Yeah, well, it's the job of every judge to do their best in showing that when they look in the mirror at the end of the day, that the ruling they issued is one that the law required, as opposed to their personal preferences, their personal policy views, or their worldview. So that is, you know, I feel like every judge shares that view, liberal, conservative. To me, the great way to judge the judges, and I think we should be judged, is to ask, do we have a ground by which we can be judged? Is there a scorecard by which Jeff Sutton's rulings or Justice Scalia's rulings can be measured to see whether they're faithful to the job of honest interpretation, good faith interpretation? And originalism, no doubt, runs into hard cases where it's pretty hard to say the history tells you one thing or the other. But what's the competition? What's the competing view? I mean, Justice Scalia used to love to tell the story. All I have to do is, if it's me and a living constitutionalist and we're being chased by a bear, I just got to run faster than the other guy. And I think he's right on that point. I don't know how to measure the scorecard of the living constitutionalist. I mean, what is the measure that you're honestly interpreting a document as opposed to simply adopting a policy preference? Substantive due process is a great example of that. How does one know what's protected by substantive due process other than the judge really likes that particular policy? That seems to me quite concerning. So it's not that originalism has all the answers. It's just, it seems to me better than any other approach. I don't know how else to do it.
So it seems to me fair to say that everyone is extrapolating at a minimum from the principles that they view as being embodied in the Constitution. I guess my question then would be along the lines of, So if you had nine people, nine originalists on the court in whatever it was, 1954, how would they have ruled on Brown?
Yeah, it's a great question. Frank Easterbrook has a great lecture where he says, you can put 9 clones on a court, and lawyers being lawyers, I'll bet you anything they'll eventually disagree. The same thing happened in the FDR court. FDR put 8 members on the court, and the 9th was Chief Justice Stone, who was a fellow traveler anyway. And of course, that became the Scorpions court. I mean, they were very intense disagreements. And your point is a great one, because you could look at they argued Brown, they re-argued Brown, they asked for briefing about the original meaning of the 14th Amendment. I'd like to think it would be 9-0. Professor McConnell, former Judge McConnell's written a really terrific article that indicates that the original meaning of the 14th Amendment would have prohibited segregated schools. But, who can say? I mean, who can say? Michael Klarman, who's not an originalist, the Harvard law professor, is really the scholar about Brown. And, I have no idea. But it wasn't, you're right. It did have originalists, though. I mean, Frankfurter was an originalist. I mean, he was an FDR appointee. He definitely took originalism seriously.
Moving on, another question. Federal judges have lifetime appointments if they don't misbehave. Many state judges are elected. Do you see that difference as helping or hindering the development of fairly consistent state constitutional principles over time?
Yeah, no, it's a terrific question. When I first started looking at state courts and state constitutions, I had the instinct that there's no way that could be a better selection system. And about 90% of state court judges are elected. And my first reaction to it was to just be puzzled. How would you use a majoritarian process to select people for what is fundamentally a non-majoritarian job, right? I mean, judges are not supposed to put their finger in the wind, look at the most recent Gallup poll to decide what to do. They're supposed to sometimes do counter-majoritarian things, and wouldn't election of judges really hurt there? Well, a couple things have happened since I first thought about that. Number one, ask yourself how political the federal process is with appointment and confirmation. I'm going to guess the questioner and many others are not too sanguine about the idea that the federal selection and confirmation process is utterly apolitical, as proved by the fact that our elected representatives are now voting almost 100% on partisan lines. So in one sense, they've merged. But here's my broader take, there are many areas too. A couple of the chapters in the book are taking on this exact point. So school funding is a really big topic in American government, trying to have equality between wealthy suburban districts and rural or urban districts without as many resources or high property values. In 1973, the life-tenured US Supreme Court rejected a claim that there should be equality in state spending when it came to poor and rich school districts, in a case from San Antonio, Texas. Since 1973, it's about 45 states have had school funding debates under their state constitution, and roughly speaking, about 2/3 of them, the plaintiffs have won, including, by the way, in Texas itself. So you ask yourself, what gives? I mean, these are elected judges. They're overruling elected legislatures. You would think they'd be reluctant to do that. And I think my answer is, even though you may have to go through the election process, even though the election process sometimes is indeed partisan, I still think these people want to be judges and not policymakers. And I'd like to think that's why in that particular area, the same thing with Buck versus Bell, same thing with criminal procedure cases in the MAP story in the book, that you often have state courts being the more vigorous protectors of individual rights, even though one's first instinct might be that the election process would undermine that. I'll give you an example. This is a very specific answer to the question, but the questioner might be interested in these two papers. A fellow named Bert Newborn, who was head of the ACLU and now teaches at NYU, in 1977 wrote a famous article called The Myth of Parity. And the title of that article reflects a perspective that might be conveyed by the question. And the myth of parity, in the myth of parity said, when I take my ACLU clients to court, I'd much prefer to go to federal court with life tenure judges than elected state court judges. That's what Burt Newborn says in 1977. In 1999, a Harvard law professor, now a Harvard law professor by the name of Bill Rubenstein, writes The Myth of Superiority. And in his article, he says, for the last 20 years, I have been engaged in gay rights litigation, and we have found it better to be in state court in front of elected judges. And he offers some explanations why that might be. Well, guess what happens if you have to run for office? You have to get out of your chambers. You have to go out and talk to the people. You have to go to Lincoln dinners, and you have to go meet the people. So when you're out there with the people, you're seeing what's going on in society. And so his view was that the elected judges were better audiences for his arguments because they were much more aware of norm shifting changes in America. So to me, it's dangerous to generalize, and there can be some areas where I think maybe elected state court judges might even be better protectors of liberty than life tenure judges.
Well, that is interesting, because one of the really interesting questions that came in, I guess we're going to have to classify this as a redirect, because it's a question along the same line. The questioner says, you talk about states being labs for democracy. In law school, he learned that this worked especially well with technical issues, for example, Californian environmental regulations. But is it really the case that you want state courts to experiment with freedom of speech or life or liberty? You're going to stand up, you're going to die on that hill?
Yeah, oh, absolutely, absolutely. So I'll reframe the question. I'll try to make it harder. And that's the uniformity point. So if we have an American value, a liberty of freedom that we prize, why, Jeff, would you want it to have patchwork protections in 50 states? Wouldn't we want to make sure that whether you're in Arkansas, Ohio, California, you get the same free speech protection, for example? So this is a really critical point to my argument. Nothing I'm saying eliminates the backstop of the federal Constitution. So something like free speech, where we really do speak with one mind, so to speak, yeah, that right has to be uniformly protected. There's no doubt. The point of the book is actually to examine the hard issues, the norm-changing issues. What does substantive due process mean? When is a search unreasonable in the face of new technology? So norm-shifting areas where the judges and justices, whether originalists or living constitutionalists, are having a hard time, that's when we want the option of a second approach. Because otherwise, if the US Supreme Court gets it wrong, we're stuck. I mean, that's Buck versus Bell. I mean, in Buck versus Bell, the US Supreme Court did get it wrong. And if we had a world in which uniformity was the sole goal, we wouldn't have been allowed state courts to use state constitutions to protect something the US Constitution didn't protect. In fact, that's the eugenics story in Nazi Germany. They had uniformity, it just was bad uniformity. So I think the question is a really critical one, that there are some values, some constitutional rights. We can't have segregated schools. There's certain things that the patchwork, no, that's the backstop point. The backstop is always there. There's nothing I'm saying that dilutes or eliminates the backstop. It's just a question of how, going forward, do we define new rights? And I think Brandeis was right about this. If we're gonna experiment with new rights, let's do it at the states first. The stakes are lower. If you make a mistake, it's not gonna have as many negative consequences. And then when you get a good idea, it can be exported to other states and eventually nationalized. And go back to the marriage story is a great example of the path to nationalization.
Okay, I'm going to ask 2 more questions, and then we will wrap it up. And this one is also from a viewer. If all Supreme Court justices come to all cases in front of them with fresh, open minds, why is it that the same groupings of justices seem to be consistently together on particular on a whole variety of cases. In vulgar terms, there seems not to be much crossing of quote party lines. Why is that?
Yeah, so I quite get the question. I quite appreciate it. Principles of interpretation matter. I mean, if a group of judges, if 5 judges or justices think that there's a mode of interpretation that one should use, it makes perfect sense that they would line up the same place as opposed to someone that doesn't adopt that method. Now, what is problematic, and this goes back to the scorecard point, you can't call it a good theory of interpretation if it turns out the outcomes always end up on one political side. That's problematic. So that's why, for me, Justice Scalia, he was probably the leading protector of criminal defendants when it came to criminal procedure rights. And you wouldn't have thought of a Nixon Republican as ending up on the side of the leading protector of criminal defendants. So just because originalism, it's really dangerous to assume that originalism or textualism necessarily means it hurts someone. So one reason you have groupings is different theories of interpretation naturally will lead birds of one feather to be on one side, birds of the other feather on the other side. Then there's the second issue where you have a shared philosophy, and I'm not sure it turns as much on originalism and textualism, but just the role of the courts. So I do think you get some justices who are more restrained. Their first instinct is not to intervene in policy-making debates, and other justices who are much more willing to say, yeah, Constitution speaks to this, we ought to say what we think it means. So that can be another thing that you get groupings of. But I wouldn't necessarily assume because the originalists are voting together that means they're reaching policy-based outcomes. Go look at the outcomes of the cases and decide after you've looked at them whether they're being consistent with their principles or not. And if they're not, at least they've left a set of measurements by which they can be gauged.
But, so I'm violating my own rules and asking a sub-question here. One of the criticisms leveled at originalism by Cass Sunstein, who's been tilting at this windmill for quite a while, colleague of yours in teaching it at Harvard, is that there's nothing in the Constitution that says it should be interpreted in the way that originalists tend to interpret it. And I'm curious what your response is when you confront that argument.
Yeah, it's a great point. So in other words, there's no originalism clause. I mean, it doesn't say all judges and justices in the future, the meaning of these guarantees is fixed, don't play with them. Absolutely, he's quite right about the premise of the question. I think the way to think about that is to ask yourself, what did judges do in 1789 or more generally the 18th century, early 19th century? And when you go back and look at that, you see, first of all, the judges did not colonize a lot of areas in the 18th and 19th century. They actually were very restrained. In fact, most of the decisions show tremendous reluctance to exercise judicial review and constitutionalize an area. But when you look at their decisions, you don't see anyone saying it means different things at different times. So that now you could argue, well, Jeff, that's because there'd only been a couple decades. There was no reason for it to change meaning over that time. So that's a fair point. But all I'm saying is when you look at those decisions, no one took the view that we can take a phrase and give it a new meaning in 50 years or 100 years. So I think the best response to Cass Sunstein on this point is just to say, Article 3 created this third branch of judges. What did judging mean? We decided early on that it included judicial review. Now ask yourself, when they decided judicial review was allowed, how did they exercise it? And I don't think there's too much evidence that you were allowed to morph things over time. But let me put the question answer this way, because it's such a good point. If you got the proverbial person from Mars and asked them to come down to America and say, how does American judicial review work? and the only evidence you gave them was confirmation hearings and campaign speeches by judges, you would say everybody's an originalist and a textualist, because all they say is we don't make the law, we just interpret the law, and everybody says that. Now that makes it look like textualists and originalists won. Now let's do the second experiment with the proverbial person from Mars. Same question, but the only thing they get to look at is the US reports and the state reporters. That's going to yield a different answer, because you're going to see plenty of decisions where they seem to be innovating new ideas. And that to me is the conundrum. We have a politically acceptable language of what judges do, and we have what judges actually do. And sometimes, you know, it goes perhaps a little beyond, because maybe they want to fix a problem. It's been happening for 230 years.
So just to wrap up, the questions, and I think the press in general these days indicate a great deal of anxiety about the partisan divides in our society. You have a great story from your own time clerking with Judge Scalia about his relationship with Justice Scalia from his relationship with Justice Ginsburg. And I'd ask you to tell that, but also to reflect upon whether the famous comity that existed between them, the warmth, persists on the court, and whether there's reason to be confident that all the people on the court together are looking out for, shall we say, solutions that will unite rather than divide.
Yeah, such an important question. We'll start with the Scalia-Ginsburg relationship. When I was clerking for Justice Scalia, Justice Ginsburg had not become Justice Ginsburg. She was still a judge, so she was not at the court. But we heard him talk about the fondness of the relationship, and I must confess that I had a slightly cynical response to it and wondered if this was a friendship of convenience, a classic Washington relationship. Well, it helps if I have a conservative friend or a liberal friend. You scratch my back, I'll scratch yours. And over time, I realized that was not true, that they really had deep affection for each other, as shown by the fact their families famously celebrated every New Year's together. So why and how, given that they were so different in their philosophies of judging? And, you know, one way to think about it is, you know, they're born in the 1930s. One's a Jewish American woman, the other's Italian American Catholic. In the 1930s, if you decided you thought about law, you'd have been lucky to go to a big firm. I mean, that would have been the most you might have even thought about. They were both classic American stories. And the way Justice Ginsburg put it, it was a self-improvement society. They both deeply respected each other. They both were striving to, you know, be able to get some responsibility, make a difference. And I think they realized that the friendship was really valuable, not just because of the affection for each other, but because they really were helping each other out by sharpening each other's views. Justice Ginsburg famously said in the one case they disagreed most vociferously about, the US versus Virginia VMI case, that you know, Justice Scalia gave his draft dissent to her before he gave it to everybody else, so she'd have a chance to correct anything and a little more time to work on her majority. And she said it was the worst weekend she'd had in a long time, but she was so grateful because he really sharpened her perspective. And so I will say I think it's my second to last face-to-face meeting with Justice Scalia. I was in his chambers in DC, and it must have been March. I think that's Justice Ginsburg's birthday. And we're done with the conversation and getting ready to leave. And the justice says, "Oh, Jeff, I've got to bring these roses down to Ruth. It's her birthday." And there were 24 roses on the table. And I said, "Wow, that's a lot of roses. I'm not sure I've given that many roses to my wife in almost 30 years of marriage." And the justice could be a wise guy. And he said, "Well, Jeff, you ought to try it sometime." I thought that was a little obnoxious. And I responded, perhaps too aggressively, "What good have all these roses done for you over these years? Name me one 5-4 case where you got her vote." And he said, "Some things are more important than votes." And I'm really confident he meant it. I shared that story with Justice Ginsburg this summer. She wrote back a lovely note. That was the last year he gave her roses. He died the next February. And that was a true friendship. And now to the current court, I happen to know for a fact that there's several justices that have very close relationships. I can't say it's the Scalia-Ginsburg mode just because that's just so special, but I think you'd be surprised that how affectionate they are for each other in spite of their disagreements about the law or the role of the courts. And so I have plenty of hope that that example is going to thrive at the court and is thriving. And yeah, it's a really nice lesson for our modern times.
Okay, well, I promise to follow up in a private call to badger you about who's involved in those relationships. And this was a real pleasure, and I want to thank you, Judge Sutton, for a terrific presentation and a terrific Q&A session. Thank you so much for joining us. We still very much look forward to hosting you in Berlin, where you were originally supposed to be delivering this talk, and that will allow you to hold your head up around your aunt and say, I've been there too.
I very much like that.
Let me just say in closing, our next event will be on Monday at October 19th, and we will have a talk on the pandemic and politics in the US with Professor Lynn Vavreck, who is one of the foremost political scientists working on elections in America today. She's the co-author of a fabulous book called Identity Crisis about the 2020 election. And she is collecting more data than I could ever imagine. And I think she'll have some really interesting things to say about the current race. So with that, let me just thank you again, Jeff Sutton, and thank everyone who tuned in for watching today. All the best.
My pleasure. Thank you.